Yes, ma'am.
My name is Jane Pelton. I live on Rattlesnake Road in Grass Valley, and I thank you for the opportunity to speak. We've heard Blue Lead attorney repeatedly assert a vested right to mine, but a close look at the evidence paints a very different picture. In fact, the evidence contradicts Mr. Chadwick's narrative and supports the argument against vesting. The mining photos from the 30s and 40s have little relevance to this discussion except as background to show the devastation that resulted from unregulated gold mining and to illustrate why county and state regulations are so very important. The critical period for vesting in this case is October 1954, when the county ordinance requiring mining permits was enacted. The ordinance carved out a limited exception for existing lawful non-conforming uses. The Hansen case does not apply here, since vested rights were not at issue in Hansen. In his book, Jerry Brady writes that after the death of Phil Fredericks in the winter of 46, that's 8 years prior to 1954, there was no one to step in for Fredericks, and that, quote, after a few years, in the 1950s, logging companies were allowed to effectively destroy the ditches and flumes. Blue Lead has produced no business records or reports from that period to support the existence of an active, legal, ongoing mining operation by the past owners of the property. Instead, Blue Lead offers only the pretense of evidence in the form of signed declarations and photos, which, when examined, just don't hold up. There's a declaration from Robert M. Cole, who was at one time attorney for Alpha Stores, in which he states that he doesn't really remember much at all, and that he no longer has any records from that time. There are some old photos of some kind of mining operation somewhere, but only 2 of the photos are dated 1954. And these 2 photos are attributed to Lyle White. Mr. Chadwick has made much of Lyle White's presence in the Red Dog area in 1954, but Lyle White did not own or lease the property. Mr. Chadwick has offered his theory that maybe Lyle White had permission. Of course, he can say anything, but proof is required, not conjecture, and that proof must be specific to the Blue Lead properties. If such proof exists, why hasn't it been produced? Mr. David Comstock, who knew Lyle White personally, says that he was probably sniping in his spare time, that is, recreational prospecting in a small way on abandoned mine claims. This is the most likely explanation.
30 seconds.
In fact, in writing about the period, Lyle White tells of spending most of his time while in the Red Dog area restoring an old cemetery and researching the lives and families of the people who were buried there. It's telling that Lyle White kept receipts for his costs related to the cemetery restoration, but no receipts for costs associated with mining. As Mr. Jank has already pointed out, the California Attorney General cautions that the vested rights exemption should be strictly construed and that substantial doubt should be resolved against granting exemptions.
Thank you, ma'am.
Okay.
Next.
My name is Don Pelton. I live on Rattlesnake Road in Grass Valley. Thank you for the opportunity to comment. On page 9 of Mr. Chadwick's May 14th memo, he says, quote, vested right determination does involve the weighing and balancing of evidence, unquote. So Mr. Chadwick admits that the initial 1954 vesting rights determination is primarily a matter of weighing evidence. I suggest to you that your first task in this case, the weighing of evidence, is similar to the task of jurors who are commonly referred to as judges of the facts. County staff has already concluded and repeatedly stated that there is insufficient evidence to support a claim of vesting. In other words, you will see that doubt in this case is much weightier than the so-called evidence. In Mr. Chadwick's latest written response a few days ago, he continued to promote his novel theory of evidence, referring again to his preponderance of evidence standard. What Mr. Chadwick has actually provided is a preponderance of speculation, asking you to accept it as evidence. Given that his so-called evidence is mostly speculation and mostly belied by the demonstrable facts, we have to conclude that the case for vesting is more not than likely. The pictorial material Mr. Chadwick submitted in support of the application is weak and doesn't rise to the level of actual evidence, except insofar as it is evidence against vesting. Without compelling evidence of vesting, there simply isn't much to say. And being a skillful attorney, Mr. Chadwick directs your attention away from the vesting issue, first by repeatedly and erroneously asserting that you and your county staff have already agreed to vesting, then spending the considerable remainder of his efforts focusing on abandonment, which would only be relevant if you had, in fact, agreed to vesting. So when all the testimony is complete today, I urge you to keep your attention on the lack of evidence for initial vesting. Since vesting has not been established, your work is done. Simply acknowledge that the applicant's burden of proof in the first instance has not been met. You therefore don't need to subject yourselves to subsequent arcane legal arguments about abandonment, nor to abstruse threads of legal reasoning about the Hansen case as precedent. Your work is done. Seems to me that the best way to protect those who have worked hard and truly earned vested rights in our county is to insist on the integrity of your process. This is the proper way to support clearly deserved vested rights and to protect the county's status as lead agency. If this commission is too permissive in its recognition of the vested right to mine, then such permissiveness would serve the profit interests of the applicant at the expense of the varied interests of the community as a whole. This is surely what the California Attorney General had in mind when he suggested that vested rights exemptions should be strictly construed and that substantial doubt should be resolved against the granting of exemptions. The doubt about initial vesting in this case is more than substantial. It's huge and easily outweighs the proffered so-called evidence. And I noticed all your questions earlier about Mr. Lyle White's activity demonstrates that doubt. Clearly, more such applications are coming your way, so it's important to set a standard for the integrity of this process now. It's important to remember that when you deny this application for vested rights, you will not deny the right to mine. You will merely ensure that mining will be done with the appropriate constraints of the county's permit process and conducted in a manner consistent with the interests of the community as a whole. Thank you.
Thank you, sir. Yes, sir.
Hi.